Thank you. And Senator Whitehouse.
Thank you, Mr. Chairman, and welcome, Attorney General Holder. Now that we're towards the end of the hearing, I'd just like to take a moment and react to two things that I think have come out during the course of the hearing today. One is, I think, perhaps inadvertently disparaging tone about federal prosecutors and our United States law enforcement mechanism. I hope it is inadvertent, but I want to take a moment to say that, having had some experience in that world, I'm extremely proud of our federal law enforcement officers, of our career prosecutors. I've had prosecutors have to go to court in body armor. I've had prosecutors have to go home to their families and explain why a security system needs to be put in their home because of threats. They take this on day in and day out, and as you know, they don't get paid a great deal. And they are, I think, among the best lawyers in our country. And I just want to make that point because I didn't like the tone that I was detecting. The second point that I want to make is one in favor of prosecutorial independence. And to the extent that you have been criticized that your decision is unpopular, I think people looking at this should bear in mind that the implication of that is that prosecutors should seek to make decisions that meet with popular opinion. And in my point, from my perspective, popular opinion is a very dangerous bellwether as a standard to hold prosecutors to. And I would not want that to emerge from this hearing as an unchallenged point. I think it gets worse when you move from popular opinion to legislative opinion. There are very significant separation of powers reasons why I, as a prosecutor, didn't want to hear from the legislature, why the Founding Fathers set up a system in which the legislature was kept for good and prudent reasons out of these prosecutorial decisions. We're entitled to our opinions. Everybody has one. Fine. We can come here and ventilate. But nobody watching this should not react to the proposition that a prosecutor should either listen to the threats or criticisms. I mean, obviously with courtesy you should, and you did, but I want to assert the proposition here that a prosecutor should not make their decision or allow their decision in any way to be influenced by legislative opinion. And if there's any way to make it worse, it would be to allow it to be influenced by talk show opinion. And there's been a whiff of that here today. And this country is going to last a long time, long after Khalid Sheikh Mohammed is safely either in prison for life or executed or whatever the outcome is. And we want to stand by the principles that have gotten us through 220 years and that will get us through to the future. And one of them is that people like us, and I say this as a sitting senator, have no business attempting to influence the prosecutorial decisions of our law enforcement officials. In evaluating this, I do want to make an additional point and get your reaction to it. In Article 3 courts, we've probably had tens of thousands of criminal prosecutions. Almost every possible permutation of law and fact and procedure has at one point or another reared its head in Article 3 courts and been disposed of and left a trail of precedent for future prosecutors to follow. Military commissions, no matter how well we may have drafted them in our recent repair of the original flawed military commissions, have now, as I understand it, only achieved 3 convictions, and 1 came by plea. So in terms of the military commission, however properly statutorily established, being able to contribute the same kind of reliability and resilience that federal courts have obtained through those tens of thousands of cases and through the exploration of all those different permutations, it strikes me that even a perfect military commission still bears some risk of unreliability in that you're either in new territory, in which case there are questions about where you go on appeal, or you're modeling yourself on an Article 3 existing legal structure, in which case you might as well stick with it. But that they are to a very significant extent, even if properly constituted, still untested. And I wonder if you share that view.
Well, first, I'd like to thank you for the statement that you made in support of the career people who work at the Justice Department and other parts of the executive branch and at the state and local level as well. I mean, you were a great U.S. attorney and a great attorney general in Rhode Island. I'm proud to say that you were my colleague, but your comments are really appreciated. To the extent that people have any question about the determination of the people who work in the Justice Department and who will be responsible for these cases, about their abilities, they should put those fears to rest. These people are among the best of the best. They could be in other places making a lot more money, but they serve their country, and they do it quite well. And I'm proud to say that I am their colleague. And so I really thank you for that. In terms of the question of Article 3 versus the military commissions, I think there's no question that there is a greater experiential base on Article 3 courts. And I think your observation is correct. We have seen virtually every permutation. I'm not naive. I know that Khalid Sheikh Mohammed in Article 3 court will do, as he tried to do in the military commission, spew his ideology, his hate, whatever. Article 3 judges have dealt with these issues before. The unique issues that I think in some ways sound unique are not going to be found to be unique. In the Article 3 courts over the past 200 years, we've dealt with, as you said, just about every permutation. There is going to be precedent for almost every decision that a judge is going to have to make, from obstreperous defendants to questions of admissibility of evidence. I don't want to denigrate, however, the fact that these reformed military commissions, though not having that experiential base, are, I think, much better than they were. I think the action that Congress took in reforming them is significant, and I think they are a legitimate place in which we can try some of these defendants. But there's no question that in terms of the experience, the Article 3 courts have an advantage.
Mr. Chairman, it was certainly not my intention to denigrate what has been accomplished with the military commissions. It was simply, and I agree with the Attorney General, that there is this experiential-based differential. If I could ask unanimous consent that 3 questions for the record be propounded by me. One has to do with where we are on the Drug Enforcement Administration's new rules that will allow them to move off paper records so that we can move to e-prescribing, so that we can build up our electronic health record network as the President wishes, timing on that determination. The second is we have people in our present bankruptcy courts who are being, I think, harshly treated under the new law. We have a U.S. trustee vacancy. When will we have a U.S. trustee recommendation from the Department of Justice? And finally, as you probably have come to expect from me, when is OPR going to put out its report on the Office of Legal Counsel? And I think my time has expired, so I'll have to take those for the record.
Well, maybe I could say, with regard to the first 2, I would certainly will certainly send you something in writing. But I think that given the fact that you've asked this question before, and I think this is a matter of great public interest, the whole question of the OPR report, if I could be allowed to respond to that. The report is completed. It being reviewed now. It's in its last stages. There is a career prosecutor who has to review the report. We expect that process should be done by the end of the month, and at that point, the report should be issued. It took longer than we anticipated, and certainly longer than I anticipated when I testified, I think, 5 months or so ago, because of the amount of time that we gave to the lawyers who represented the people who are the subject of the report, an opportunity to respond, and then we had to react to those, or people in OPR had to react to those responses. The report, as I said, is complete and is now simply being reviewed by that last career person in the Justice Department, and my hope is that by the end of the month it should be complete.
I thank you, Chairman, and I extend my gratitude to my colleagues for that
Well, thank you.
slight extra time.